Good evening all, and welcome to the Criminal Law Q&A session. My name is John Dove, and I am the founder of Speed Mooting, or the National Speed Mooting Competition. Thank you for coming along tonight. I'm sure this is going to be quite an enjoyable evening, and it should be interesting for you to pick up a lot of advice in relation to practicing in criminal law. We have a slightly smaller panel than advertised tonight, but I'm sure it's still going to be an enjoyable evening nonetheless. So I'm going to start by introducing each of our panelists. So up first, we have James Oilveira-Agnew. Would you like to introduce yourself?
Yeah, good evening everyone. My name's James. I'm a criminal barrister with a bit of immigration and a bit of family when I have to, but yeah, mainly practicing in criminal law. Southeast circuit, so I work mostly London and then all around the glamorous southeast, so Lewis and Hove and Dover and anywhere you can think of.
Excellent. Next we have Oliver King.
Evening everyone, and I'm sorry if you've heard this before if you're a repeat offender. Yeah, I'm Oliver King. I'm at St John's Buildings Chambers, which is based in Manchester. But actually I work out from the Chester Chambers. So my practice is exclusively crime. It tends to be dominated by sex cases these days and violence. And I tend to service the courts in Cheshire, so Chester, and North Wales, so Mold and Carnarvon, and increasingly over in Liverpool.
Thank you. And we have Jack Troup as well.
Hello everyone, like Oliver and James, I'm a criminal practitioner. I'm based at 15 Winckley Square Chambers in Preston. We tend to cover pretty much anywhere in Lancashire, Cumbria, occasionally getting over to Liverpool and Manchester. Primarily my practice is criminal. I do the odd bit of personal injury and civil work as well, just to supplement my criminal practice.
Excellent, thank you Jack. Right, I'll talk you through how the evening is going to work. So we'll start with some pre-prepared questions. So when you signed up tonight, you may well have submitted some questions. We'll start by working our way through those for the first 45 minutes or so. From there, we'll then move on to any questions that you might have on the evening. So you'll notice that there's a chat box in the bottom right-hand corner. Throughout the evening, if you think of a question, you can pop it in the chat box. Alternatively, when we get to the second part of the session, if you're feeling brave, you can pop your hand up and come on camera and ask a question. By way of house rules, I've just asked that you all keep your microphones on mute throughout the evening, unless you are speaking. So we'll jump straight in then. And the first question that we have is a nice easy one, or maybe a difficult one to answer. Why did you choose to practice criminal law? Oliver, would you like to start us on this one?
Sure, yeah. Well, I'd always been excited by crime and criminal cases growing up, really. So back in the 90s, it was things like John Deed, Kavanagh QC, and that gave you a bit of an insight into the criminal courts. And then I took that interest further and went and sat in my local Crown Court, which was in Maidstone in Kent at the time. And then I'd go uptown to the Old Bailey and sit there during half term. And I just was encapsulated by it. It fascinated me because crime and criminal courts involve proper adversarial courtroom advocacy. It's not like a civil case where perhaps people are arguing over intricacies of law, or a commercial case where, you know, it's who's liable. It's about people's lives, and that's always interested me. I suppose the voyeur in me. I did a common law pupillage, and so I experienced the range of areas. But again, it was crime that I kept coming back to. It was crime that kind of, you know, made me want to get up in the morning. And fortunately I had a flair for that, and solicitors instructed me more in crime than any other practice area, and that's how I've ended up specialising in crime. It's also, I think, that the draw for me is that it's less about law. I think even at our level, it's less about law. Of course, you've got to know the law, but it's more about establishing facts, understanding how people tick, witnesses, jurors, you know, your opponents. You've got a lot of people that you have to sort of keep happy and handle. So it kind of brings out the amateur psychologist in me as well. But it's that kind of people side of it that I like, and the contact you have with people that I don't think you would have to the same degree in other practice areas. So those are my reasons for doing crime.
Thanks, Oliver. Jack, what were your reasons for doing crime?
Well, it was an early age. I was very interested in criminal law, mainly because my father was actually a police officer. So that was always the sort of thing that from an early age got me interested in talking about crime and that kind of thing. But then as I sort of went to university and things like that, I did many mini pupilages and other bits of work. I didn't just do many pupilages in crime. I did them in other areas, family law, civil law, that kind of thing. But I think the thing that attracted me most to crime was when you are representing a client in crime, and this isn't to obviously say anything bad about other areas of law, but quite often you have somebody there who is in a very, very difficult situation, and you, through your own hard work, through your own ability, through your own communication skills, you can make a significant difference to that person. You can make a significant difference to that person's life and what happens to them. So for my mind, it's a job satisfaction type of thing. Having experienced other areas of law, I don't think I had the same job satisfaction coming off having won a small road traffic accident case in a PI as I have with winning a Crown Court trial or even a Magistrates Court trial. So that's the difference for me.
And James, anything to add in relation to this question?
Well, yeah, I think what Oliver and Jack have said, really. I mean, I started in a purely criminal set. I did go over to the other side for a little while, and I did a sort of common, mixed law. So I did civil. I did you hit my car on a roundabout, no, you hit mine. A little bit of whiplash and all these things. And yeah, I mean, the thing is with crime is it's proper, isn't it? It's the proper thing that you want to do as a barrister. You've got fundamentally a jury trial where you are talking to 12 ordinary people. There is a judge, but the judge doesn't make up his decisions, and you're dealing with people. I mean, it's an industry, it's the area where you're dealing with people day to day, and everything else, you've got insurance companies, and you're not really doing that. And I think, like a lot of practitioners, the nitty gritty of the law, I'll be honest, it's not really massively interested me. I just like getting up and doing advocacy, and you can do that in crime. You've got to know the law, but you can think on your feet, you can work, every day is different, you don't get stuck in things. So, I think criminal law, and, you can make a living out of it, despite what a lot of people say. But yeah, no, crime was always the one that was proper barristers do crime.
I have to say, I completely agree with all of the panelists here. I practice crime myself. And I think one of the things that's really interesting about this area of law is it is just so fact sensitive. It's not about black letter law. It's not about, as you say, sometimes who crashed into who. It really comes down to the facts and how well they can be presented. I think more so than that, you really do have an impact on people's lives. If somebody's been the victim of an assault or a theft or whatever it might be, if you can achieve justice for them, you've actually made a significant impact in that person's life, rather than you've secured a financial claim or whatever it might be. So I think from that point of view, there is a lot of job satisfaction there. Okay, we'll move on to the next question. And it's, can you describe a general working week in the life of a criminal barrister or solicitor, or barristers on the panel, and the nature of the work involved? Jack, would you like to start off with this one?
Yeah, I can do. Obviously, it usually depends on your seniority. So I think more senior practitioners tend to know their diary much more in advance than more junior people, because, of course, they're booked on the sort of 2, 3, 4 week, multiple week trials. I can't really speak from that perspective. I'm still quite junior myself, but from a junior point of view, a typical week normally involves, you might have a 1 or 2 day trial, 3 day trial in your diary. go to court, you'll obviously probably crack that, and your clients will plead, and then in the end, the clerks will try and fill up your diary with bits and bobs. So that can involve short sentence hearings. It can involve mention hearings for other people within chambers, and quite often you might get yourself into the magistrates' court as well if you're as junior as I am. So that's sort of a typical working week, I think.
Oliver, I'll say this as pragmatically as I can. At the more senior end of the bar, does it differ much?
As Jack said, I think you have a bit more control over your diary the more senior you are, and you can perhaps look further ahead and know what you're doing. But probably I'll deal with this more when we come to the hardest part of the job, or aspects of the job that you don't like, because it can, even at a more senior level, it can all change depending on Crown Court listings departments and things like that. So you can think you're doing one thing and then you find you're doing something else, and you pick it up and run with it at the last minute. But a typical week for me, I'm just thinking about this week actually, and so I mean I had Monday at home, which was great because I was able to catch up. One of the things we have to do now when we prosecute cases is 14 days after the plea and trial preparation hearing, if it's a not guilty plea, is provide an advice to the Crown Prosecution Service, just sort of letting them know that it's the right charge on the indictment, that all the evidence is ready for trial. If there's any sort of holes in the evidence, then you advise them, which gaps need to be plugged and so on. So I took the time to do those on Monday. I'm quite bad at getting those done on time. Tuesday, I was in North Wales. I was offering no evidence on a case that was listed for trial. The reason I was offering no evidence is because it was quite a tenuous forensic link with the defendant and the drugs. His DNA was on some of the knots in a car, but the driver had already pleaded guilty. He was a passenger, and they served on us, I was prosecuting it, a report that said it could have got there through secondary transfer. So, if he'd touched the other guy and the other guy had touched the bags, or something like that. And there was no other evidence, so I advised that we should drop the case against him. So Tuesday I turned up at court, the defendant turned up, defence counsel, I offered no evidence. In the afternoon I had a conference at a solicitor's office, so I left court, had a bit of time to get a bite to eat, read through my notes, and then a conference at 2 o'clock at the solicitor's office, met a client. I had my defence cap on now, so I've been prosecuting in the morning. Now I'm thinking about it from a defence point of view. I was advising a guy who is accused of raping his biological daughter, but it's not straightforward because she's in her 20s and it's a pretty dysfunctional situation. So we're going to offer to the prosecution pleas to what used to be the old incest, familial sex, but not guilty to rape, and I think they'll probably take that. Today was a couple of sentences where people have previously pleaded guilty. So it was a robbery in a town centre. A girl snatched another girl's handbag. So it was opening the facts, setting out the guidelines, and then she was sentenced. Tomorrow I'm back doing a couple of sentences. Friday, a couple of pre and trial preparation hearings. So it's the first hearing at the Crown Court. It might be they plead guilty. It might be they plead not guilty. If they plead guilty, it will go for sentence. If they plead not guilty, then we'll set a trial in the new year, which I'll endeavour to do. And then Friday afternoon, I've got to go to the town hall in Chester, which is one of these new Nightingale courts, to test the video equipment for a 2-week trial I have starting next week that involves witnesses who have been video interviewed. So the sexual allegations, they've been video interviewed. The interview has been edited, and we play that to the jury as their evidence in chief. So I've got to go to this new courtroom that's been newly fitted out and check that everything works. One of our jobs now that we've seemed to absorb as counsel, that we go along and see equipment. I've got to do that on Monday, then I'll be to blame. So that's kind of a typical week.
Excellent, thank you. And James, how about a typical week for yourself? Does it sound similar to that?
Yeah, so quite similar. There's no typical week. I think that's the thing that's so enjoyable about it. Yeah, so I mean, Monday I was in Aylesbury trying to do a sentencing on a multiple extreme pornographic images and child sexual images case. The powers that be, for some reason, had not decided to order a pre-sentence review. So when we turned up on Monday, Judge Sheridan wanted a pre-sentence review, of course. The earliest probation can get in is the 28th of November because our guy's on remand. So we've now been pushed back for sentencing to December. Tuesday was, again, representing a client on a child grooming and meeting in a car park, a sort of police honey trap case. Today I was in Isleworth, I was prosecuting. I'd prepped up my trial for today, got to court, was meant to have 9 witnesses, had none. And then after a lot of messing around, ended up offering no evidence. Then got given another trial to cover at the last minute in a different court in Isleworth, and ended up having that adjourned because we didn't have an interpreter. So that was that. And then, then tomorrow I think I've got a couple of conferences, and Friday conferences in the morning, and then I've got a PTPH in the afternoon, preparing. And again, as Oliver said, this will come up in the question of what don't you like. I've got to prepare a 5-day trial, which is supposed to start on Monday next week, but is not going to. And I know that, but I have to prepare it anyway, just in case it does go ahead. So yeah, every day is different. And although the diary's prepped quite a long way in advance, it can change last minute. And as Oliver said, if you get a couple of pleas in, then things can alter quite dramatically. But no typical week, really. It's what's enjoyable about it.
I think the moral of the story is expect the unexpected. It could be last minute prep. It could be a defendant entering a plea you don't expect. Who knows? But with this job, the only thing you can guarantee is that you don't know what's going to happen. Right. We'll move on to the next question. And it says, what is the most difficult case that you've worked on? And what were the skills that were needed for it? Oliver, would you like to start us on this one?
Sure. I've made a note of a case, actually. It's a case from about 5-6 years ago. What was difficult about it was that, as you guys all know, when we do sex cases, ordinarily the offender is male. And this was quite an unusual case because it was a mum who had abused her 2 daughters, one who was 9, the other 12, over the web for some guy in America who was encouraging her to do it. And so it was different to the norm. And I met the 2 girls at court on the morning of trial. The 9-year-old was very sweet and innocent and didn't really understand why she was there, or the implications of what her mum had done. The skills I used in talking to her was obviously, took my wig off and just communicated to her on her level, tried to explain to her that she was here to, tell the jury what mummy had done to her. But the 12-year-old did have a sense of what had happened, and she was turning 13. She had become very, very angry and very distrusting. And so when I met her, she really pulled the shutters down. She wasn't very communicative with me, very, very distrusting. So I had to sort of build up a rapport with her. And this was actually before parts of Section 28 were implemented, so that they were both required, even the 9-year-old, to come into court, but they were behind a screen. And so it was asking them those sort of preparatory questions to get them comfortable before you then dive in with the difficult questions. And of course, they were 2 different personalities, so it was adapting and moderating my questions for the 9-year-old and then for the 13-year-old. The mum was convicted. She got 12 years. She didn't show any remorse at all for what she had done. And at the end of the case, their dad, who had no idea of what was going on. He'd been at work all the time it was happening, and the two girls were at court, and the 9-year-old gave me a big hug and thanked me. And I have to say, it was one of the few times I've not been very good at holding back my emotions, because I was quite taken by it. But it was a really, really difficult case, and you know, as I say, we have cases that involve lots of male offenders, but very unusually a mum abusing her kids. So it was a hard case, and I've not forgotten it. So that's the one I remember.
That really does sound like a tough case. James, have you had any particularly difficult cases?
I think sort of similar lines with it. I think if you start to get involved, in sexual offending, if you start to sort of deal with sexual offences, you quite quickly sort of find that you're instructed on more and more, and you get a bit of a niche of them, and you can find yourself become a bit of an expert quite quickly. But I think that sort of goes two ways. I mean, generally, sexual offences, certainly with children, are always tough to start with. You know, there's always things you have to go into, I say, with your eyes open, quite literally, because of course, you know, a lot of the time there'll be a dispute about the category that pictures fall into, and you'll have to sit down with, you know, prosecution and go through a lot of images to try and argue which category they should be in. But I think very similar to Oliver, and I had a case that finished just before the lockdown. The actual details of it weren't particularly difficult, but it was somebody where my defendant was a middle-aged gentleman, but he had very heavy learning difficulties. There were two victims. Again, one was 17 and one was 14, but they both had, they were quite disabled with learning difficulties. And one of the problems that we had was, obviously the vulnerable witness sort of initiative was enforced, so the victims were given quite a lot of sort of help, but I had to push very hard for my defendant to be given the same kind of help. And, you know, we needed an intermediary, and I had to have quite a lot of arguing with the judge about an intermediary being put in for my defendant. And it was just one of those cases that was very difficult, because everyone was sort of in a position where you didn't want any of them to be in court, or even of giving evidence in court. And there was a lot of issue with the police recording of their evidence, where, as I'm sure Oliver's had experience of as well, the police tend to lead their witnesses through their evidence in a quite disastrous way if you're a defence barrister. So there was quite a lot of arguing, but it was quite a difficult case, because they were all very, very difficult to deal with, and it was a very trying, I don't want to say that harshly, but it was a very, very trying case that, given what it was about, didn't help. But I think any of the sexual offences stuff is always pretty difficult.
Thank you. And Jack, any difficult cases that you've worked on?
Yeah, I chose one that's sort of slightly on the different end of the offence spectrum to everybody else. So it was a case, I think it was about a year ago now, 18 months ago, a harassment case. My client had been accused of leaving voicemails on his local MP's constituency answer phone, very abusive messages. And the difficulty, well, there was a couple of difficulties to it. Firstly, there was a legal point, which I won't go into. It's boring, and you don't need to go into that. But the other aspect of it, which was very difficult, was the client's defence, because he was saying that, notwithstanding the fact that this person sounded very much like him, introduced himself using his name, and talked about the things that or the grievances he had with this MP, it wasn't him on the voicemails. He didn't do it. And this was all a conspiracy by the MP and her staff to effectively silence him and fit him up. It was, quite frankly, it was a nonsense defence. And so he wasn't for taking any sort of pragmatic advice that you might think you should give him, and he effectively wanted his day in court. So the difficult aspect of it was for me, walking a bit of a tightrope of making sure I'm looking after his best interests, making sure that I am presenting his case as robustly as I possibly can, but also, of course, remembering my duties to the court to make sure I'm not putting effectively fanciful things to witnesses and actually putting proper questions. So that was the difficulty there. He was a very demanding client, somebody that every couple of questions he would sort of be wanting your attention and saying, I want you to say this to her, I want you to say that to her. And that was just the difficulty of it. And I think it taught me a lot about having patience with clients, having empathy with clients, trying to understand their position. And I think a lot of the time, even though we eventually lost that case, as you may guess, I think people just want to see that there's somebody on their side fighting for them and they're trying for them, even if it's not the best case. So I think that's something that it taught me, and I think that the skills, obviously, that came with that is the patience and the empathy you have to have with clients. And I think, as Oliver and James have said, with other people in the case, obviously with witnesses and everybody else, you have to sort of communicate with people on the human level and try to understand where they're coming from. I think you're on mute, John.
I'm on mute. Not too bad. We've got through, I think, 5 of these sessions, and I've managed to not talk on mute, so I've done well so far. Yeah. I'm happy enough with that. But yeah, that can certainly be the hardest part of the job when you have a client. I remember from defending, sometimes, you know, they'll give you their instructions, and ultimately your client's instructions are your client's instructions. And sometimes it can be a difficult case to present in court, but ultimately you've got to present that to the best of your ability, and of course within the bounds of the professional rules. The next question is one that some of our panelists have touched upon already, and it is, what is the hardest part of the job? So I'll ask James to start on this one.
I'll go with something a bit different, because I think Oliver and Jack will probably touch upon the fact that you can't plan anything, the inability to sort of get instructions more than 10 minutes before a hearing. But one of the hardest parts, certainly in criminal, defendants. Defendants can be one of the hardest parts of the job. I mean, I remember representing a chap who was up on a string of robbery offences, and he'd gone around, allegedly, local bookies, basically sticking them up with a knife. And he was on CCTV in 4 of them. And one of the things that was, CCTV was a bit blurry, but it was reasonable. But one of the things that was most obvious was the attire that this gentleman chose to wear. And it was a very bright pink Kappa sort of jacket with a great big red stripe across it, and a pair of bright green trousers. And he was on CCTV in all 4 of the betting shops wearing this lovely outfit. And as you can probably imagine from this story, I turned up to represent him on the first day of trial in the Crown Court, and he walked into court wearing the exact same clothes. And I just had this moment of, I just had to try and get him out of this jacket and into a jumper that I had to find from somewhere, because it was his issue was ID. He said it wasn't him on the video, and he turned up in the same clothing he'd worn in all 4 of the robberies. So I think you have to have a bit of a thick skin, because you know you are going to stand up in front of judges, and you're going to run things that you think in your mind, no one is going to buy this, and you can get hostility from judges. I mean, there's some that will be very against you if they think you're running this. But you know, if your client's instructed you, and you obviously you don't know any different, he told me that it wasn't him. He said it was a misidentification, and that's what I had to put to the court. And of course, what you have to do is do that to the best of your ability without sounding as though you don't believe a word of it. But he was convicted on all 4 counts of that. And yeah, I don't think he's wearing the same jacket anymore, but there we go. But I think so you know, the day-to-day stuff, but I think defendants can be difficult, and running the cases so that you genuinely do your best for them, you know, even when you can see all the flaws in their case. I think that can be difficult sometimes.
Thank you, James. Jack, what do you find to be the hardest part of the job?
Well, I think it's probably what James has anticipated, but I think it's work-life balance is probably one of the more difficult aspects of the job. You find it very difficult to plan anything sort of in the evenings or even at weekends, with friends and family, obviously in non-COVID times. Invariably, if I've got a weekend away booked, Friday to Monday, I will probably get a call on the Thursday afternoon from my clerks, and they will say to me, "Oh, I've got this case, really good case for a instructing solicitor that only wants you. You know, they can't do without you. Are you sure you're really away on the Friday?" And you've just got to make this judgment call, really. And I think it's very difficult to say no in this job to work, because of course you don't get paid for holidays or sick pay or anything like that. So you don't have anybody to cover for you if you are, you know, if you're unavailable, other than, you know, other members of chambers who may be able to pick up the work, but they're still looking out for their own practices. So I think that's the most difficult thing, is it does take a big toll on your personal life, the professional job.
Thank you, Jack. And finally, Oliver, what do you find difficult about the job?
Well, I agree completely with James and Jack. But for me, it's all those things that are outside your control, and it seems increasingly there are more and more things outside our control. So, you know, fees, you know, what we actually get paid for doing the work we do. You know, the government can come along on a whim and change the fees, normally in a downward direction, and, you know, because we're self any redress in the same way an employed person. Listing of cases. So, you know, you might have a case that you've been involved in from the beginning, you fix the trial for a date you can do, and then at the last minute, the listing department has it, they move 2 weeks, but you're in another, and inevitably the client's annoyed, the solicitor's annoyed. It's a case you really wanted to do, but it's just been taken away from you. Delays. We're fixing cases at the moment in Chester for August of next year. So it's the frustration actually from both sides, prosecution and defence, that there you are, you've got your witnesses ready, the case is good to go, but we've got 9 or 10 months before that case will actually get before a jury. Prison staff not bringing your client to court. This is a regular problem. So there you are at court, you've read the brief, you're all ready to advise your client, you're still sat there at 5 to 1, and then the usher comes out and says, "Oh, Mr. King, I'm sorry, he wasn't on the list for the prison staff, so they're not bringing him today." And then you go into court and the judge says, "Well, that's all right, we'll deal with it on Monday, but guess what, you're not there on Monday." So all that work you put in, now someone else goes to court on Monday, and they get to do the case and get to earn the fee. Witnesses. Frequently, witnesses not turning up. I think James just said when he was at Isleworth Day, 9 witnesses didn't show up. He had to want no evidence. But of course, he would have had to prepare that case and read all those 9 witnesses' evidence and prepare his questions. So that's frustrating. Defendants that go bandit, that don't turn up, or turn up to the wrong court, or you know, go AWOL. Naughty judges. I had a particularly unpleasant experience last week at Chester with a judge who, for various reasons, was annoyed that he'd been landed with this case. The technology was playing up, then the screen, when we cross in this apparently COVID compliant court, the jury couldn't see the witness. It's taken them 6 months to occur to them screen, and the judge went off like a rocket, and he blamed me, and he shouted and bawled at me in court, and I left the courtroom just thinking, I've had enough of this. You know, that can be one of the hardest parts of the job. I think Jack said when you know, you've got a difficult defence to run, and you meet hostility from the judge. You know, there are some judges, thankfully they're now a dying breed, but there are some judges who can be very personal in court, you know, and say to you, well, you know, have you advised your client? Are you doing your job properly? And, you know, it can be hard not to be, you know, we're thick-skinned most of the time, but there can be that day where you've had a stressful morning and a judge says something and you do take it personally. And of course, you don't have any redress against a judge. If you worked for an organisation and a boss spoke to you like that, you'd probably have a grievance. But because of the nature of how judge you, and you can't really do anything, it's all those things that are outside your control that, for me, are the worst part of the job.
Thank you. Some very interesting answers there. The interesting point that you picked up on there when you were talking about the judges getting personal and asking whether you've advised your clients, because that was one of the things that always gets me in the magistrate's court, when you've got a box to tick on the form that says, I've advised my client about credit for a guilty plea, and the judge will still say, you have advised your client of credit for a plea. You're thinking, yeah, I've ticked the box on the form. So that's one of the questions that always got me.
Does your client not know that he's on the CCTV committing this offence? You go, you know what, I actually didn't actually watch the CCTV. I'm negligent in my job, but I'll go back and have another go, shall I?
Yeah, I didn't read the evidence before I gave him advice.
Yeah.
Right, next question. This is open to anyone because I don't know who might know the answer. What kind of exercises do criminal chambers ask for in pupillage interviews? Don't know if anybody might know this.
Well, I didn't have my interview that long ago, 5 years ago now, I suppose. But anyway, so the exercise they asked me was typical kind of pupillage scenario. So you're on your feet in your second sixth, and it's a Friday afternoon. You're in chambers. You're asked to go and cover somebody who's breached the bail over in some magistrate's court somewhere, and then they tend to ask you questions around that. So what sort of things would you be doing ethically with that client? Would you, if he showed up and said, if you showed up and that client said, I don't want you, I want so-and-so barrister, he's more senior than you. What would you do if that client, would you apply for bail in that scenario? How would you handle not having all of the papers? That kind of thing. I think it's just about testing your temperament and your ability to think through things logically and come to at least a reasoned decision from what you've learned on criminal procedure rules, what you've learned about barristers' ethics, that kind of thing.
Excellent, thank you. And does anybody else have any input on this one, or was it too long ago?
Yeah, sure. I'm going back now to sort of the because I went for quite a few pupillage interviews back in the early noughties, and so I'm just kind of drawing on what different chambers did. One chambers I went to, you got some papers in advance and you had to sort of make a bail application, but deliberately set against you because the guy had a long record. It was utterly hopeless, but they wanted to see that you gave it your best, and you tried to emphasize all the positives, of which there were few. Another pupillage interview I had, they said to me, what would you do if you were Home Secretary? You walk into the office of Home Secretary tomorrow, what would you change? What would you change about the criminal justice system? Things like that. The pupillage interview where I was actually taken on, they said to me, in this job, you have to persuade people, especially juries, to sort of embrace and take on your case, see it from the defendant's point of view. When have you ever had to do anything like that? And I was told after that the reason I got the pupillage was because of the answer I gave to that question, and my answer was back when I was at university, I was in the special constabulary, and I got called to a multi-story car park where a guy was going to jump off, and God knows how, I persuaded him down, and that I gave them a bit of detail about that, and they thought that stuck out. So it can be really varied, from a kind of practical exercise to drawing on your own life experience to demonstrate the skills that you will need as a barrister.
Excellent. Okay, I think we'll jump on to one more question before we jump on to any spontaneous questions. So if anyone's thinking of any questions that they want to ask, if they want to start popping it in the chat box now. Final question from the pre-prepared questions that we'll look at is, what sort of work experience would boost a pupillage application or training contract application in criminal law? James, would you like to start us on this one?
Yeah, I mean, this is a difficult question because I think, certainly with criminal law, you've got people in chambers who went through Oxford or Cambridge, they did their law degree, they've done their, I apologise, I call it the BBC. I don't think it's called that anymore. That shows my age a bit. But I think it's the BVC or the BPTC. They go out of Oxford or Cambridge, they go straight into the bar school, they do mini pupillages, they do a few bits of work experience, they apply, they get the pupillages at the sets in London, and that's that's their way of doing it. But conversely, we have people in our chambers who worked in CPS for a number of years, and they transferred over. We've had solicitors who have worked in criminal law firms, and they've transferred to become barristers, and they've worked that way. We have people who used to work in shipping. I, in my early days, was a forklift truck driver, and I think one of the things with criminal law is it's important. I think it's important that you have a sort of wide range of people. It's one of the things where diversity sort of comes in, especially in criminal law, is that you are representing everybody. You don't have an average client, and I think it's important that people have a sort of experience of dealing with that and of dealing with lots of different people. So I think for me, you would look at doing mini pupillages. If you're doing 10 or 15 mini pupillages, it's too many. You don't need to do that many, just do a couple. And possibly even sort of marshalling. If you've got a bit of time, marshalling is a really good way of sitting on a bench and seeing what a judge does and then getting the experience. And I think, Oliver said right at the very beginning that one of the things when he was going into criminal law is he went to his local Crown Court and watched some cases. And I think that's a really good way of doing it. You can be unlucky and you can get me as a barrister and try and watch me doing advocacy, but sometimes you get good barristers doing advocacy. And it's really good, I think, to go and watch people actually work and pick up, because after a while you'll see judges don't like this, or the judge didn't like that point, and you'll see what people do and how people react. And I think you can pick up a lot of good points in that. So just getting out there, sort of experiencing the criminal courts and watching what people do is really important. And perseverance. There will be people who apply for a pupillage, get the first one they've applied for, and everything is happy. It doesn't happen to most of us. It's a long, hard slog, and you've just got to keep at it, and just build up that bit of experience. And I think, again, as Oliver said with his story about being a special constable, it's those things that make you stand out in criminal law, because people will think he's got that way of talking to people. He understands people. I think that's really important in criminal law.
Yeah, I think that's absolutely crucial, because you can have all the academics in the world. Ultimately, as we've said, it is about how the law affects people on a day-to-day basis. You need some common sense, you need some life experience. And I think that really comes into this area of law in particular. Does anybody else have any comments upon any experience that might help a pupillage or training contract application? I think that was quite a comprehensive answer, to be honest. I can't really think of much else to add. Okay, all right. We'll jump onto the questions, and they're coming through thick and fast in the box. First question is: have there been any cases you've refused to take or regret taking? Might be helpful if someone wants to explain the cab rank rule to start with this one before answering.
Yeah, I can jump in if I like talking. No, we as a general rule don't refuse cases. So unless there is a specific reason, I have prosecuted on a case where I was the advocate at the first hearing for the defence, and so of course there was a bit of a conflict of interest there. So I could refuse that. But as a general rule, we don't refuse. So if it comes in and you are of the competency to do it, then you will do it. So we don't ever refuse cases as such. So I think, yeah, I mean, we get what comes in, and we sort of run with it. I mean, my clerks are fairly helpful in that they will, you know, if I get offered a case in Devon on a Friday afternoon, they will probably sway it to somebody else because it's a long way for me to go. But as a general rule, you get what comes into your pigeonhole.
Excellent. Very good explanation there. Right. The next question we have, how was your first experience in mooting?
I can go with that
Yeah,
one.
we'll go with Jack on this one.
Well, I was actually a first year law student when I did my first bit of mooting. My tutor at the time basically said to me about 2 days before this moot that he had organised, "Oh, we've had somebody drop out. I've seen you like to talk in seminars. How do you fancy doing this?" So I just sort of threw myself into that basically. I wasn't particularly well prepared because obviously I only had 2 days. I didn't quite understand what mooting was at that point actually, and I didn't understand that we all had to turn up in suits. So I just turned up in jeans and a shirt. I wasn't really trying to be smart, but it was, I think, for me, a big part of why I wanted to then go on and have a career as a barrister, because I enjoyed that experience thoroughly, and it meant that I, in my second year, went for national competitions and things like that, and third year I kept going into mooting competitions. So it was a big catalyst for me. It was a big thing that propelled me to push myself towards being a barrister.
Yeah, I think it's absolutely crucial, whether you want to be a barrister or whether you want to be a solicitor performing advocacy. I think it's absolutely crucial that you get involved with mooting, because when it comes to you going in for the training contract application or pupillage application, if you've never done a moot before, it's going to be pretty tough to convince that panel that you're actually interested in advocacy. So then get the experience as early as you possibly can. The next question. Do you have any advice about obtaining mini pupillages in the current climate when a lot of them have been cancelled without further notice?
Shall I answer this one?
Please, yes.
I think different chambers have different policies, and so some chambers, a bit like mine, it will be terribly formal, and you apply to a pupillage or mini pupillage committee. They'll have a look at your CV, and then they'll offer you a week or whatever over the summer. But actually, remember, we're all self-employed, and so if you see a particular barrister at court, and you know you're enjoying watching the case, don't be afraid to approach that barrister. I think we're all really friendly actually, because we all remember what it's like to want to be a barrister and to kind of to be a bit afraid about approaching one. But you know, we won't bite. If I'm in court and a couple of students are sat there and they approach me, you know, I'm always happy for them to come back, or for one or other of them to come back and spend a couple of days with me. So you can approach barristers individually, because we are, after all, our own bosses, and you know we can decide if someone does a mini pupillage with us. So that's one thing. But with chambers that have a kind of policy, a central policy, and you have to email them, I think it is a bit difficult at the moment, because of course the chambers as a company has to be seen to be complying with you know all the COVID rules and so on. So they have to limit the number of people that are going into chambers and things like that. But a lot of chambers have been moving on to social media. So I know, for example, exchange chambers have held a couple of events on Zoom where they've invited those that want to do mini pupillages, you know, to join, and they've spoken to barristers, and I think they've done some exercises where they've discussed cases and things like that. So social media is great at the moment with the situation we're in. Things like LinkedIn, Facebook. So that's perhaps another way you can get a flavour of what mini pupillage might be like. But as I say, the other thing is maybe just approach. I personally don't mind people talk with me for a couple of days.
Thank you. That was a really good answer, and it's something I've said for a long time. I think if you are going into court, don't be afraid to speak to any advocates. If you see any solicitors, you see any barristers, feel free to talk to them. The worst thing they can tell you to do is to go away. But most people in this profession are very friendly, and I found that I obtained a lot of my experiences through that method. So I spoke to people, said, what's your case about? What is he doing? And then eventually it naturally leads into the question of, do you offer any work experience? Do you offer any pupillatures? Do you offer vacation placements? And quite often I get a business card, send them an email, and it goes from there. So you never know what it might lead to. I always remember being in Liverpool Crown Court, spoke to a particular advocate there. Turns out he was with Merseyside Police, and I ended up doing some work experience with the police force solicitors unit. So you just never know what it can lead to. So it's always important to go into court. If you see someone, always feel free to have a chat. Okay.
And you know what? Actually, all I was going to say is we become barristers. Well, perhaps I'm just speaking of myself here, but we are performers. We are quite egotistical. We do like the sound of our own voice. We do like talking about our cases. So if someone approaches me and they ask me about my case, we do actually like at what we do and getting people involved. So, don't be afraid.
Excellent. Right. The next question we have is a little bit doom and gloomy. Has the reduction in legal aid combined with the rise of solicitor advocacy spelt the inevitable and irreversible decline of the bar? Does anybody want to jump in on this one?
No for solicitor advocacy, yes for legal aid.
Excellent. Nice and simple.
No, I mean, solicitor advocacy, I don't think so. I still think, if you go to most Crown courts, in most cases, you'll mostly find barristers. There are some solicitors that do that work, but people tend to be, and again, I'm generalizing, but people, as Oliver said, people tend to become barristers for one reason. They tend to become solicitors for another. I mean, most barristers, we like to perform, we're egotistical, we like talking. We don't particularly like getting proofs of evidence from clients at 4 o'clock on a Friday afternoon in an office. We don't particularly like filling in hearsay applications and various documentations and filing bundles. So people tend to go into the professions for different reasons. And I think, I don't think there's anything, solicitors are perfectly as able as barristers in the law. They just like doing different things is what I've normally found. So I don't think solicitor advocacy is an issue. Yes, I mean, the cuts to legal aid are absolutely appalling, and the amount of people that can get it now is terrible. And I think we've got a bit of a bump up now in the graduated fee schemes and things, but you can still find yourself on a legal aid case, preparing an entire case, going along to court, it cracking. And you bunging in your legal aid bill for £46.50 for your, 3 days prep that you've done and a day out of your diary. So I think it is going to lead to people having to consider, certainly at the junior end, whether they can feasibly run a purely criminal practice on the basis that if they are purely doing legal aid work, then, I don't know about other people, but I can't imagine myself being able to have the sort of practice I had in 2008 nowadays, and being able to function as a sort of purely criminal barrister. So I think once you get up a little bit in practice areas, legal aid's still a reasonable source. But certainly at the lower end, it is terrible, and the cuts as COVID has shown, the cuts have decimated everything. And whether we get back or not, who knows?
Excellent. Thank you, James. Does anybody else want to comment on that question?
Just an observation, if I may. A few years ago, the Crown Prosecution Service recruited a lot of solicitor and barrister advocates to prosecute cases at the Crown Court. And I remember locally, everyone was full of doom and gloom. they thought it would spell the end of the bar as we know it. Then the Criminal Defence Service got set up, and the government recruited advocates who would attend the Crown Court. So obviously barristers in independent practice wouldn't get instructed. A couple of before it all went back to how the reason why it was unsustainable is because actually as a profession we're cheap, and they can't get around that. We bear our own costs. We don't get a pension. We have to make our own pension service or a high street solicitors firm. Whole host of employment rights. You've got to pay into a pension for them. You've still got to pay them if they've got days out of court. And so it's gone full circle. And all these people that were employed to be Crown Court advocates have now been absorbed back into the kind of. So in terms of the end, it's been tried, and it never works. The work always ends up coming back to the bar. So I wouldn't worry about that.
Excellent. Looks like there's light at the end of the tunnel. Right, we've got two questions, and I think I'll combine these into one because they seem to cover the same area. Firstly, what do your individual chambers look for in pupillage applications? And then secondly, apart from the usual skills, i.e. critical thinking, communication, etc., what unique attributes do you think one would need to make it as a criminal barrister? So essentially, what skills are your chambers looking for from pupillage applicants, and what skills do you think are crucial for a criminal barrister?
I had a solicitor friend once that said to me, I think the only thing you need to be a barrister is a mouth and a memory. I think that's pretty much encapsulated for me. I think if you have the confidence to stand up and talk, and you can demonstrate that through experience, whether it be legal experience, whether it be mooting or advising clients, or even if it's something wider than that, I think that goes a long way on a pupillage application. But I think as well, showing that you're able to master a brief, I think is very important. Again, it doesn't have to be legal. It can be, as long as you're able to show that you're able to research, you're able to read, you're able to recall things, whether it be, working at a mobile phone shop, for example, and you're able to advise people as to what type of particular phone that they should get because particular models are different, and you're able to remember all of the differences and be able to process all of that. I think that's very important to chambers, showing those skills. I don't think it necessarily has to be legal. It just has to be an ability to master a brief, an ability to communicate it thoroughly.
Excellent. Great answer there. Does anybody else have any contributions on this answer? Whereas Jack nailed it, do we think? Yeah, I think so. Okay, we'll move on. The next one, nice simple question. Do criminal sets generally welcome career changes, or does youth triumph?
Well, I can jump in here. I think with crime, actually, someone who's come from a different career, who's got different life experience, is something that's very appealing, because of course chambers are going to receive lots of applications from those who have done their A-levels, they've gone straight to university, they've gone straight to bar school. And there's not really much that stands out about those applicants. But if it's someone who's maybe spent 10 years doing something completely different, and they've developed the skills that they need to be a good barrister, but in another way, obviously they'll have the academic qualifications, but they've done something else first. I think, personally, that would make that applicant more appealing than someone who's just sort of, been on that academic conveyor belt. I'm not trying to discourage anyone who's young, of course, and of course, chambers recruit young people as well as those who are more mature. But I do think these days, with it being as competitive as it is now, if you've done something else first, that can that can put you to the top of the pile. So actually, it's the opposite to what Paula has asked. I think a career changer or someone with a bit of life experience might triumph over someone who's younger who hasn't really done anything.
I think just picking up on what Oliver was saying, certainly in my chambers, I don't know what it's like in other chambers, but my chambers, it's the barristers that do the sifting of the applications. So we all sit down and we look at them and we mark them, and they then go to the pupillage committee. So I think it's worth remembering that we are usually doing that because we're self-employed. We're usually doing that on our evenings. We're doing that on a voluntary basis. And most of the time we've got, 30 applications to get through in a few days. So having something that stands out, like Oliver says, something that's interesting, something that's life experience, I think goes a long way towards it. That doesn't obviously have to exclusively be somebody who has done another career. It can still be somebody relatively young. Never discourage somebody, as Oliver said, coming straight out of university and going and applying to be a barrister. But I'd just try and think about trying to make your application interesting in one way or another, to try and make it stand out, as Oliver said.
Thank you. Very interesting answers there. Right, our next question is there anything that you would recommend university students to do now that will improve our chances of making it as a criminal barrister? I think we've spoken. Oh, James, coming on.
No, I was going to say it's a bit of a hard one, isn't it? I mean, I mean, you've sort of spoken about the things you can do. It's difficult at the moment, obviously. I mean, you can't just all sort of swan into a Crown Court and watch a case because, as I think we're all practitioners away. You have to get through 8 screens of perspex and sit on a socially distanced chair at the back of the court. But you can still do things. But I think really it sort of ties back to the last question. I mean, I think it's really about sort of getting a grip with people. I mean, if crime is your area, then it's about sort of understanding people and just sort of keeping abreast of news, keeping abreast of stories, watching things. I mean, I've had a barrister about 10 years older than me, and every morning used to buy the Sun and the Daily Mail. And people in chambers were some were quite put off by his choice of newspapers. But he always used to say, well, no, he doesn't, he said, I don't like them, but the jury do. These are the 2 most popular newspapers. And so I think it's a sort of question of getting an idea about people. And I think you can use the time to sort of, why do you want to do criminal law? Because that's going to be a question that's asked. And, it's really just getting sort of experience. Even if you haven't got life experience, you can get life experience from sort of keeping up to date with things and what general public's feelings are. And, certainly in the jury trial, that's going to be the most important thing, is connecting with those 12 people. And I think you can do that by sort of experiencing things, even if it is just reading through papers and news stories and seeing what's out there.
Thank you. Okay, we've had a question here about in relation to qualification. So essentially the question is asking about the 4 Inns of Court. So firstly, we've had somebody asking about the difference in the 4 Inns, and secondly asking about the 12 dining sessions as well. I don't know if anyone wants to very briefly give an explanation in relation to that.
Sure, I'll jump in. So yeah, 4 Inns of Court, you have to join one of them, and it's that inn that will be your inn, from which you're called to the bar once you've completed the bar vocational course. It's really a personal choice. I joined Gray's Inn because when I did the bar course in London at the Inns of Court, Gray's Inn was right there next to the lecture theatre, and so I didn't have far to walk. So I joined there. I could nip in for a pint at lunchtime. They did a really good carvery, so it was purely for that reason. Now I look back and think, actually, if I'd been a bit more savvy, I would have looked across the 4 Inns at which ones have the most money to offer students for grants and scholarships and things like that. I didn't apply for any of that because I just assumed that it was the preserve of Oxbridge graduates. I kick myself now because I realise, in fact, that money is there for everybody and not just people who are extremely academic. It's there for people from all sorts of backgrounds, people who might get a 2-2 degree, but they've worked really hard and they've built up some good experience and can demonstrate that they really want it. So what I would say to anyone now thinking about which inn to join is have a look online. All of them have got web pages now. They set out what the ethos is, what their awards are, how you apply for those awards, and join an inn that can offer you something. Apply for all the loans, all the scholarships that you can, and even if it's just some money towards your books when you're starting out, that makes a big difference. So I think you've got to do your research and now go for an inn that's going to perhaps be able to offer you more.
I did exactly that. I joined the inn that offered me a scholarship. That was the only reason I chose Inner Temple.
And of course, the 12 qualifying sessions is, to become a barrister, you must be able to eat 12 dinners. I mean, it's vital to our work that you can do so. But I think it's, the qualifying sessions are a funny one because they, I benefited. I was living in London, so for me the 12 qualifying sessions were fairly easy. I mean, I know people outside London do struggle with them a bit, and but again, I think, as has been said, I mean, not just the scholarships, but in terms of qualifying sessions, look at what's offered. Lots of inns will offer lectures, they will offer different evenings, they will offer things that you can do for your qualifying sessions that isn't necessarily just sitting and eating dinner. And then I think be prepared. You will go. Lots of inns still have the same sort of mentality of things, and having been relatively recently before the lockdown to a bencher's night, you have to be prepared that you can't leave your table after the first, grace. You have to finish your dinner. You can't leave before the second grace. There's lots of different things, and you are going to be sitting in a very big room wearing a gown, and it's, I must say, not the most pleasant experience sometimes, but make the most of it. And I think I'm Middle Temple, so we've all picked different inns, and I'm exactly like Oliver. I didn't apply for anything and I kicked myself for it. It's there, and it's I encourage everybody now just to go out and use it.
I think it's worth mentioning as well, it's not just London that you have to go to. I think a lot of circuits now try to do inn dinners on circuit. So I did a few in Manchester, for example, because that's north where I live. So you don't have to think I've got to go to London for 12 times to do all of these things.
I'm a fellow member of Gray's Inn, just like Oliver. And for example, when I was at bar school, when I competed in the Gray's Inn mooting competition, that counted as one of the dining sessions. They had a weekend in Leeds, which counted as 3, so it meant I didn't have to go down to London. So you really can build up a lot of the training sessions, or dining sessions, just should say, without actually having to go all the way down to London. And James was talking about the dinners there. It's, if you imagine Harry Potter or Hogwarts, that's the way I would describe it. And I always remember one time I was the junior in hall, sat in the gown, and after dinner I had to stand up and toast Erimus so that everybody could leave. Right, okay, on to the next question. Got a question that says, I don't know if this has been asked, but are you all defence barristers? I think it might be helpful if one of you could explain how your practice works as a self-employed barrister, in terms of the fact that you both defend and prosecute.
Yeah, I mean, I can jump in on that. I mean, I think most of us probably defend and prosecute. CPS obviously have in-house advocates, but they have agents, and there's various tiers of CPS prosecution, grade 1, 2, 3, and 4, and then specialised lists. And the way the prosecution works is that you apply. They have sort of 5-year sentences. No, they have 5-year runs of sort of the various different parts. So you applied for, say, a grade 3, you can do that. So you can apply to upgrade, and then at the end of the 5 years, depending on how much work you've done, you can carry on or you can reapply. So most criminal barristers will defend and prosecute. some in our chambers only prosecute. One in our chambers only defends. He doesn't like the idea of going over to the prosecution side. But I think for most criminal barristers, they will prosecute and defend. And so, yeah, you get your instructions from the CPS in the same way that their agents do, and you are briefed in the same way. So as a self-employed barrister, you accept work from both. So yeah, so for me personally, I prosecute and defend. I defend more than I prosecute, but I do both.
I think it's quite rare to have somebody that only does one or the other, although it does happen. And I think it's worth saying as well, I do prosecute not just on behalf of CPS, but also local authorities. I do trading standards work, so various local authorities have a pot of money to prosecute people for trademark offences and health and safety, that kind of thing. So it's not just the CPS that you can work for, although they are the vast majority of the prosecution work out there.
And then the key difference is on the solicitor side of the profession, you tend to do one or the other. So, for example, I defended for many years, and now I've moved across to the Crown Prosecution Service. So I only prosecute, and that's one of the big differences between the two sides of the profession. Okay, the next question we have, what are the most significant ways in which your work has been affected by the pandemic, particularly as crime does not lend itself to remote working? Does anybody want to comment on how COVID has affected their...
Well, I think it's been difficult for a lot of people, because I think the way that billing and money works, I know, sorry to talk about money, but the way that it all works in crime is you don't really get any particular payment until the end of a case, until your trial's finished, your client's been sentenced and the bill's been put in. And there's been a vast majority of cases now, as Oliver said. I think Chester are listing things in August 2021. I think I've heard horror stories about June 2022 as well in certain cases. I'm sure that there's probably worse than that even. So that's a big difference. It's affected the cash flow for a lot of people. It's also, I think, affected your sort of ability to talk to people, because over Zoom, there's only so much you can do. Quite a lot of, I think quite a lot of the job is done in the robing room, where we all talk about what we're going to do and what cases we're going to deal with, and we try and come to some sort of resolution outside of court. It doesn't always happen like that, but quite often you can narrow down the issues. So we're missing that aspect of it as well, is the sort of the talking about a case before it gets into court, which I think can often help quite a lot.
Has anybody here done a CVP hearing yet?
I have one in a couple of weeks, actually. I'm waiting for that.
Done a couple, yeah.
Yeah, in Cheshire and certainly in North Wales, it's so today I had a case in Mold, a case in Carnarvon. I obviously couldn't do both, so I checked with the judge in Carnarvon. It was all right to CVP in with CVP cloud video platform, so a bit like Skype, but it's secure. And I was able to do my hearing from one of the conference rooms at Mold, present a sentence in Carnarvon. And actually the judges in North Wales are well, for the time being anyway, are really flexible and really happy to accommodate counsel. So it's brilliant, because it means, whereas I might have had to return that case because I couldn't have been in two places at once, I was able to do both and get paid for both. So hopefully this is, I mean, I'm hoping, as I'm sure James and Jack are, that one positive thing, if I can say that, to come out of CVP is that it's been a catalyst in the criminal courts for us embracing and bringing forward technology that may not have really come into the courts for a number of years. So it's forced us to have to embrace that technology, and judges at the moment seem happy to allow us to appear in courtrooms from another courtroom or another court centre, which helps us, of course, do more cases and earn more money. So long may it last.
Except in London. Judges in London have been terrible. We're getting called in on cases, PTPHs. I had to go along to court last week because the court had emailed a trial date for March 2022, and we all got called into court. Everyone applied for CVP. It was rejected across the board. So prosecution, defence and defendant turned up in court for the judge to say, have you all had the email? And we said, yes. And he said, and this is okay, is it, for the date? And we said, yes. And he said, okay, thank you very much. And off we went. And there is still, I think, I don't want to say provincial courts because that sounds very condescending, but a lot of the courts outside London seem to have fully embraced technology, understood the benefits of it. They're getting on with it. They're getting through stuff. It's fantastic. And a lot of the London courts are stuck in this idea that council must attend. We must attend. Council have had, I had a judge say, council have had an easy ride the last couple of months, being able to sit at home working. And you think, well, yeah, but what's wrong with that? We're getting through twice as many cases. So I think hopefully it will kick on, but London seems a bit behind the rest of the country in adapting to the CVP in particular.
Interesting. Okay, I think we're coming up towards the end of the evening now. Apologies if we've not gotten to all of the questions that are in the chat, but we did receive quite a few there. But what we're going to do for the last sort of 10 minutes or so is I'm going to hand over to each of the panelists just to leave us with a final few words or parting piece of advice for the students here tonight just before we finish. So I'd like to turn to Jack first, if you'd like to leave us with your final words.
Thanks for putting me on the spot with that. Well, I think I've said it quite a lot of times over the course of the evening, but I'll reiterate it again and just sort of try and add a bit more. I think you need to make sure that you are showcasing your own uniqueness in whatever applications you put. So whatever makes you an interesting person, whether it be what sports you're into, whether it be the fact that you have started your own blog online and you're talking about current affair issues. Any of these things, I think, just to put on your application to make you stand out. And I think the other thing I want to touch upon is I know there's a lot of doom and gloom around, particularly about sort of legal aid cuts and things of that nature. And it is bad, of course it is, but you can still make a living out of this job. It is a very, very good job as well. I'm very lucky to do this job, and I count myself as very blessed to be able to go to court every day and represent clients and be able to do that. So I wouldn't ever say to anybody, be put off by the legal aid situation, by the money situation. Just be aware that you're not going to be going into this and you're not going to be turning yourself into a millionaire, I don't think, unless you're very, very good. Certainly I don't think I will. But yes, I think that's all I can say, really.
Excellent. James, any final words for us?
Yeah, probably just to sort of mirror that, really. I mean, I'm always a harbinger of doom and gloom, and I always sort of hark on the bad points. But no, it's the best job in the world. It's fantastic, and as Jack said, you're a privilege to sort of deal with people every day and be a part of things that you would never be a part of, and a sort of life that is incredibly rewarding. It's incredibly hard work. There's a lot of late nights, early mornings. There's a lot of frustrations, but at the end of the day, I think you get that in every job. And the criminal bar is certainly one that is absolutely a rewarding experience. I think perseverance, keep on at it, and you definitely get a career that you love. And I think just be prepared if you go into the criminal bar. You will have to answer the question of how do you defend guilty people? How could you defend someone like that? You will answer that at least 17 times at every party. Have an answer prepared. I tell people that I work in veterinary law, and they don't ask me any questions then, so that's nice and easy. So, but it's a brilliant job, and I think as a profession we all stick together, we all stand up for each other, and there's a camaraderie that I think you need, because you are self-employed, you are fundamentally your own person doing your own thing, and but certainly the sort of camaraderie of a roving room or talking about cases is fantastic, and I think it's definitely a job that is well worth of all the areas of law pushing into. Yeah.
Thank you. And finally, Oliver, do you have any words of wisdom for us? Yeah,
well, I suspect, like many of the viewers here tonight, who I can only see a couple of faces, mainly names, but I was sat there when I was in my early 20s, undergraduate, doing my law degree, wanting to be a barrister, doubting myself, thinking, well, you know, I'm at a reasonably good university, but it's not Oxford or Cambridge. I'm not a straight A student. I'm going to get a 2-1, not a first. I don't have pots of money. Shall I knock this on the head now? Shall I just be realistic and do something else? And actually, there wasn't anything else I wanted to do, and I persisted. And you know, it's competitive, and you do get knockbacks. I went for umpteen pupillage interviews. Some of them never even had the courtesy to reply. Others said thanks but no thanks. Some said, oh, close but no cigar. And then as I built up the experience and I kind of worked out what I needed to say, and I gained in confidence, I started getting a couple of offers. And there were 2 main offers I got, and one of them was in Chester, and that's the one I took. So, you know, of course, you've got to be realistic. It's a big financial commitment, and it is very draining, filling in all those application forms and, you know, trying to justify why you want to be a barrister. And the world has changed just in the 20 years I've been doing it. But if you are committed and if you do put in the work, you can still get there. And when you do get there, as Jack and James have said, it is a job like no other. Yeah, the lows can be lower than other jobs because of the subject matter that you're dealing with. Sometimes you're dealing with people at their worst, and you're seeing horrific things. But the other side of the coin is the highs. You know, when you've represented someone like Jack said, someone who perhaps can't talk up for themselves, who maybe the police have exploited a little bit in an interview, taken advantage of, you know, and you represent them and you get the right verdict. It's sheer exhilaration, and I can't imagine any other job could give you that. So follow your dream is my advice.
Excellent, great advice there from all 3 panelists. Well, this brings us to the end of the evening. I'd like to start by saying thank you to all 3 of our panelists. You've given a lot of great advice tonight, and hopefully our students have taken a lot that will help them in their future. Thank you to all of you participants that have turned up tonight as well. A lot of great participation tonight, and that chat box didn't stop, so some great questions that were submitted in advance and during the evening as well. Next week we have the 3rd Q&A session in our series of Q&A sessions. Next week it will be on family law. If you're interested in that and you haven't signed up, feel free to go on the website and sign up for it. I'm sure that's going to be a very interesting Q&A session. And then after that, we do have one in 2 weeks' time on personal injury and clinical negligence. Of course, as you'll be aware, we are the National Speed Mooting Competition. We launched a couple of competitions coming up towards the end of the year. We launched them only a couple of days ago, and all 3 have filled up already. So they were very popular. I'm looking to launch some more advocacy and mooting competitions shortly, so keep an eye out on that. If you'd like to be notified about any of our advocacy or mooting competitions, go onto the contact page on the website, fill in your details, we'll put you on the mailing list, and we can notify you about any further competitions that we have. Tonight's evening and the whole series has been sponsored by publicspeakingtuition.com, and I'd like to just say a final thank you to everyone that has come along tonight, and I'll see you next time. Thank you.